Um, what, who were your early role models in life? Who were the people you looked up to?
It's difficult to say that my favorite people, of course, were people like my father and I had an uncle that I thought was the greatest thing since sliced bread, and I thought they had the right outlook on life. My father had gone to a minor seminary, and in the seminary, his degree is from St. Mary's in Baltimore, but he lost his vocation, for which I was eternally grateful. Otherwise, I wouldn't be here. But,
What kind of values did he raise you with?
I don't know. There was nothing I noticed about it. I mean, the values I suspected everybody out there is you had to work, you're expected to be decent to other people, and avoid sin. Got that from the nuns, too, parochial school.
Um, what kind of line of work was he in? I'm just curious.
Well, he found when he left the seminary that the demand for people of a Magna degree in philosophy who could speak Latin, Aramaic, and Greek and things like that were kind of limited. So he wound up going to work for an oil company, originally Sinclair, then Standard Oil, and finished up his life was co-owner of a small oil company called Burnex Fuel Oil, which sold oil to stations and owned stations and things.
At what time did you did you find an interest in the law?
You know, I went over that a couple of times over the years. People asked me the same question. I didn't know any lawyers, but I used to go to movies on Saturday, and they depicted lawyers as living pretty well. That is, the lawyers always seemed to have nice apartments and drove nice cars and dressed well. As near as I could tell, they didn't do much. But they talked a lot, and I thought I could do that. So by the time I was 11 or 12, I wanted to be a lawyer. I know that when I started to St. Rita High School, they asked what I want to be, and I said I want pre-college because my object was to be a lawyer, which made me kind of unique in the St. Rita, which was a technical high school. So, but I've never wavered since, either in my analysis of what was right about law, being a lawyer, or the fact that I wanted to be one.
I might ask part of that over again because the phone rang, just one ring there. So you elected, what was at St. Rita's you decided?
No, I said when I enrolled at St. Rita's, by that time I was 13, and I said I wanted to be a lawyer, but I wanted to be a lawyer 2 years before that, although I didn't know it. As I say, I'm talking entirely from screen images of them, you know, with how the lawyers acted. They were treated with respect. They looked well-dressed, and they seemed very smart, so I thought. But what they did was talk.
I think I read something similar. It might have been something your brother was.
Yeah, I said
about Judge Hardy.
Yeah, well, that was his idea because that's the only lawyer he knew. But if you remember, you know, I'm sure you did not. Judge Hardy, when we sat him, he was at home all the time telling Andy Rooney things. You never saw him in a courtroom, so he was not my role model at all. But my brother thought he was, and I didn't bother correcting him.
When did you go to law school?
I started law school in 1949, September 49. And graduated 2.5 years later. I'd passed the bar 2 years later, so I was past the bar before I graduated from law school. But that was kind of a freakish accident. Can't happen now.
Yeah, I was wondering how does that work?
Well, when I started to law school, I had been in the Army and out. I graduated from college in '49 from Elmhurst College, and the Korean War was the first war where you were exempt as a student, as near as I could tell, from the draft. I think it was a mistake, but one of the interesting aspects of it was that as soon as you graduated, you were out of school, your number came up and you were gone. So that would mean that if you graduated in June and the bar was traditionally given right after Labor Day, by the time the bar came up, you'd be long gone. So the Supreme Court passed a rule that if you were in your last semester of your senior year, and the dean would certify that you could, and there was a chance you were going to go into service, or a reasonable chance you were going to service, you could apply, and the Supreme Court gave you a chance to take it early. So I went to the dean and said, if I go to summer school, I will technically be a second semester senior, in September. And I was 4A, which is a discharged veteran, but still of an age to be returned. I said, I was with the 7th Infantry Division who liberated Korea, and I was in Korea for months. I said, what if somebody, and I'm a convenience of the government discharged me, what if somebody calls us? What are the chances of that happening? I said, about 1 in 8 million. He said, that sounds like pretty good odds. So he said, okay. The Supreme Court certified me without he didn't know how to take it. And then they moved the bar from September to the last of July and early August, which meant I took it while I was going to summer school. But I had to promise the dean I'd come back and finish college if by some fluke I passed it. So I passed the bar and got the results in September, and then finished the second semester.
What appealed to you about the law?
An enormous number of things. One of them is it's intellectually challenging constantly. Nothing is the same. It's not a rut thing. Every case is somewhat different, even if it's only the people involved, but it's more than that always. It's a constant challenge. And it's a business or an occupation where you have somebody on the other side, just as educated as you are, taking a different position. So that you have to constantly keep alert, and you have to respect somebody else's point of view, learn to live with it, and you're selling what you think the law is or ought to be. And it changes the whole world. I mean, it's the law that makes us function. So it intrigued me, and it still does.
Intellectual stimulation.
Constant. No sameness to it, other than the fact that it's a sameness of enjoyableness.
Yeah. I want to kind of backtrack a little bit. I understood that in working your way through college, you drove a cab, you were a short order cook.
Oh, I did everything. I said that was it. Remember, I'm a depression-oriented child. If you could make money, you could. And so the first job I got, I was, besides selling or peddling newspapers or Saturday Evening Post, was as a dishwasher come short order cook at a restaurant on the west side of Chicago, Austin and Madison. And I told them I was 19 and I was a short order cook. They said they had just filled that one, but they had a dishwasher opening, so I said, yeah, I'm a good dishwasher too. So that summer I worked as a dishwasher and filled in for the short order cook when he was either duty to drunken quarters or taking a day off. But I did everything. I worked in the Ovaltine plant. Later on, after I got out of the Army, I drove the cab. But I also was a post office man. I mean, delivered mail, worked in a YMCA camp as an archery instructor, did whatever I could. Mostly to pick up enough money to take out pretty girls like my wife.
You met her at Elmhurst?
Met her at Elmhurst College.
Tell me about her.
Oh, she was a beautiful little girl. There's some pictures of her up there. I think you may have seen them. I met her the first day I started at Elmhurst College. And I thought she was about the cutest thing I'd ever seen. Never changed my mind, by the way. And we were married for 1 week short of 56 years before she died. And
when did you go to work first for the county prosecutor's office in DuPage County?
Well, while I was still in law school, having passed the bar, I worked for the law firm Daniels, Guile, and Greisheimer. Now, back up. Until fairly recently, assistant state's attorneys and state's attorneys downstate practiced law. Cook County was the one where they're not, but they got paid more in Cook County. When everybody else was making, state's attorneys were making $13,500. State's attorney of Cook County was making $27,000 or 27, from $13,500 to $27,000. He got twice as much, and so he wasn't supposed to practice law. We did, and assistants did too. Daniels was the grandfather of the guy who was just Speaker of the House, and he was the state's attorney of DuPage County. But I went to work for his private office until I graduated from law school. And then he gave me a job as an assistant state's attorney May 1st, 1952. But I had been working with him in his private office from September on, 51 on. And I was going to stay for about 2.5 years and learn how to be a trial lawyer and then go out. But in the meantime, Daniels ran for Attorney General, lost in the primary, but he was succeeded by the Guile of the partnership, Daniels, Guile, and Greisenberg. And I went to work for him, stayed there, I stayed with him. And at the end of 2 years, I was trying felony cases, and I was head of the felony thing, burglaries and murders and rapes and funny things like that. At the end of 2 more years, I was first assistant, so I thought I'd stay around for a while and see what it was like. And then Guile got elected county judge, so I ran for state's attorney and got elected.
That was 59?
59.
What were some of the big cases you prosecuted?
Oh, lots of them. I tried a number of murder cases, 3 of them against Al Woodward, who was the father of Bob Woodward, of all the president's men and so on. Al and I tried 22 jury cases against each other in a period of about 5 years, including 3 murder cases. But they were, it was an interesting, I tried a lot of important cases. Of course, every case is important to the people involved.
1964, elected circuit judge in
Right.
Page County. What was the transition like, going over from the prosecutor side to sitting on the other?
Well, I also tried civil cases, remember, so that was not unaware of what the duties of a trial judge were. And I was in court almost all the time as assistant and as state's attorney. When I was state's attorney, I tried all the heavy cases myself. It took me a while to learn almost all of them, but toward the end I started to delegate some authority, which came hard upon me. First of all, I enjoyed it. It was more fun than you could have. You should. There were times I thought if I could afford it, I'd pay him for the job. But I thought the importance of having good judges was significant too. And so I was nominated. The transition was not as easy as you think, not because of the difference in work, but because you had a constant feeling you want to get down and try the case yourself. You have to learn to back away from it. It's not your case, but you have to be there, keep alert.
And other judges have told me, like Justice McMorrow told me when we were talking, that you're constantly learning something about some new field of law or
Amen.
some new area.
Every case that comes before you, as I said, was a little different. And the lawyers have worked with that case for months and sometimes for years. And they know all about that and that thing. And they educate the judges. So in whatever area they're working in, criminal, civil, or transactional stuff, real estate, anything at all, they're going to have to educate the judge, which means he has to be a fast study. He has to learn. And the way to learn is from the lawyers. And so that it's a learning process. You'll have to learn to listen and to remember, which is the basis of being a good lawyer or being a good judge.
How did all this prepare you for being appointed U.S. Attorney in the Northern District?
I was a prosecutor for all those years, almost 15 years before. So the prosecution of state cases and criminal cases is precisely, and federal cases is precisely the same. The difference is the crime itself, but there's a difference between trying a burglary case or trying a murder case or a drunk driving case. So that the way you try cases, the way you present them, the rules of evidence are the same.
About what time did you meet up with Jim Thompson? This be about?
Well, Jim Thompson was sworn in to be a lawyer before his class. That is, he had passed the bar, got sworn in early, so he could go to work for the state's attorney's office. I met him in Springfield when he was arguing a case in the Supreme Court. Supreme Court used to set all murder cases for the same days or week. And I was down there arguing a murder case from DuPage County, and he was arguing a case from Cook. But I had never met him because he was, as they say, fresh out of law school. Tall, skinny, crew cut, and shy, believe it or not, except in a courtroom. But the 2 men that handled appeals for Cook County, one guy named John Gallagher, another fellow, Rudy Janica, And I went back to the library in the Supreme Court room when I finished I had 2 cases, and he was in the middle, and went back, and those 2 were there. I said, "You're on, you're at bat." And they said, "No, we got a young guy arguing this." So I went in and sat and listened. At that age, he was probably 24. He was absolutely magnificent. He was a great appellate lawyer, and he still is. Anyhow, that's when I first met him. We had lunch together with a group of us, about 7 lawyers, including George Layton. And he was extremely shy. I don't think he said 4 words during the time we were at lunch. He sure got over that fast. Anyhow, I watched him progress. He stayed in the state's attorney's office, left the appellate, went to trial work. We encountered each other with various committees of the Bar Association. Then he taught school for a while. Then he went back to the Attorney General, and that's when I snagged him to be first assistant. Because when I was asked to take the job of U.S. Attorney, and I did not apply for it, one of the conditions were that I could pick a first assistant who would replace me if I went on the bench, back on the bench. A first assistant who would be acceptable to everybody, and is a man of integrity and ability, and could do the job well. So I talked to James. The interesting thing is I had to talk him into it. And I had to have Ogilvy, who was the governor's help, to talk him into it. Because Thompson decided he wanted to run for sheriff because he wanted to be governor. And as Ogilvy pointed out, I had told Ogilvy not to run for sheriff. But he ignored me, but I was right, he shouldn't have. But it worked out. And do you remember that the man he hired as a investigator, Kane, turned out to be corrupt? And Dick Ogilvy was probably the most honest person we've ever had holding public office. We've had some, but a lot of them, but this guy was just tops. And he got tagged with this, what the newspapers called the mark of Cain. And so anyhow, Ogilvy pointed out to Thompson that he thought that was a bad route. And Thompson said, "You did it." And he said, "Yeah, but I was the exception." I'm right. The only other man I ran for sheriff was ever heard of again, and I remember with any degree of distance, was Richard Daley, the old man. And that's because he lost. Do you know who ran against him and won? His name was Elmer Michael Walsh. He was a nice guy, but nobody ever heard of him again. Which was my point exactly.
Appointed U.S. District Judge in 1971, so you
Yeah.
weren't in the U.S. Attorney's Office for very long.
No, a year and a half.
Wow.
Actually, I was hiring people before I came down because I had agreed to take it. They were waiting for Foreign to finish the Conspiracy 7 case, which was on trial from September through April, and nobody thought would happen. So for a while, Thompson had to sit in, or he was appointed to fill in for me for about 5 weeks before I came down. The Senate of the United States has no sense of urgency for appointments, if you notice. They move at their own pace. So,
what brought you to the attention of President Ford to be named an appellate?
Charles Percy.
Charles Percy.
Yeah, no question about it. All I knew of President Ford. My law partner and boyhood chum, John Erlenborn, was a congressman. And on one occasion, Ford came to speak for him, for Erlenborn, and my law partner's name was John Erlenborn, who was a congressman for 20 years from there. And he had one fundraiser a year, and he always had a speaker. Ogilvy was one of them, but Percy was one of them, and so was Ford. Ford was in minority leader in the House, and I met him there. There's a modest, funny story that went with that. Is my job was to make sure the newspaper people had enough to drink to be happy, and not so much to drink they couldn't drive or get somebody to drive them home. So I would stay in the back with the press when Well, let me put it in a very simple way. It's the difference between reading a play and seeing a play. When you're in a trial level, you see the play. You see the interaction of human beings. You see the emotional problems and everything else. And you get, until you get to a verdict, there are no set in line facts, because the finders of fact make that decision. It's finders of fact do so impressionistically, not analytically. If you talk to a juror after a trial and ask them what they thought, you could tell right away they were lying, or you could tell they were telling the truth. It was trustworthy, that sort of thing. That isn't what you do up here. Up here it's an analysis. The facts have been determined downstairs in the trial level. When you get up here, it's a question is whether the law was properly applied and applying the law to the facts as determined. But in each case, what you cover is determined by what has happened in the trial level. What happens in a trial level, it's what's determined what the lawyers put in their complaint and their answer or the indictment. They don't go beyond that. They have to stay within the parameters of that. So the facts are set up essentially by the facts sought by the lawyers, argued to the judge, and the finder of fact makes the finding of fact. Then a motion for the new trial or a judgment notwithstanding the verdict comes in. That determines what we get to hear. If they don't ask for help down there, they can't ask for it up here. So they come up, and here they argue analytically. These are the facts. This is what went wrong, and this is why it should be corrected. And the opposite side says that was done right, and this is why it should be affirmed. That's true in this court, it's true in the Supreme Court of the United States, exactly. So there's another reason to be a lawyer. They determine what laws are being looked at and how they're looked at.
From your perspective, what has been the chief challenge or intellectual challenge to doing this kind of work? What's the most rewarding part of the work?
On the appellate court?
Mm-hmm.
Analysis of cases and thinking you're doing something to advance justice is probably the best you could say. But I do not think there are any cases that are not worthy of our review or anything of that. I do not feel that I'm so brilliant that I can't take care of people's problems, because that's what I'm there for. That's what we're all there for, to do justice.
I've read in reviews of your work on the bench that although you come from a background as a prosecutor, you're very careful to make sure that the rights of the defendants are taken care of and they're protected, that you take a very even-handed view of things.
I hope so. I hope so. And you don't divorce yourself from your own background any place along the line, but I know what the pitfalls are, and I know what the temptations are. And yes, I think that if we don't watch the rights of everybody involved, the victims and the defendant, legal rights, their constitutional rights, then we're doing it an injustice to everybody. When I insist that the government prove the defendant guilty beyond a reasonable doubt, or the defense attorney insists on it, we're protecting all of us. There's an irresistible impulse if you're a prosecutor to think you're on the side of righteousness. And I'm not saying you're not. But don't try to tilt the field a little bit so that the righteousness wins out. It's righteous only if you stay within the rules. The defendant in his actions outside of the courtroom doesn't feel bound by any rules. We are. And if the police officers, prosecutors do not stay within their bounds, they might as well be criminals, because in fact they are. But it's not a mean thing that they do. They think they're doing right, and that makes it even more dangerous.
It's said that when you're on the bench, your questions are straight to the point. You've done your homework, but you've got a sense of humor that comes across as well.
You've noticed.
A little bit.
Yeah. Yes, I think great Irish background. Life is fatal but not serious. If you can't pause and laugh a little bit, it's a terrible world we live in.
Let me ask that again after, I think Eileen's probably going to grab that line. Yeah, she's got it.
Yeah.
So you're not afraid to have a little fun too at the same
Oh,
time.
no, I didn't have a little fun. Life isn't worthwhile.
Yeah. Yeah, some of that's found its way into your opinions. I think one that comes up frequently is Sealand Services versus Pepper Source, a spicy case that finds its origin in shipments of Jamaican sweet peppers.
Well, that's one of them. Some of them lend themselves to it. I wrote an opinion some years ago that had to do with Tony Accardo, and I couldn't resist a chance to tweak him a little bit, so I did. His house had been burglarized and it was never reported, but 6 burglars turned up dead. And in the process of looking into his, bringing him into grand jury, his gardener who called him and told him about the burglary disappeared. Went back, was old country Italian. They opened a grand jury investigation to see whether Gardner's civil rights had been violated, which I enjoyed all by itself. And then looking into the house, they found some things that might be connected, a radio scanner or things like this. They also found $250,000 in cash. And so they seized it. Under what theory, I don't know, and the government's, one of their theories before the district court was it was a possible source of temptation for the crime, motive for the crime. I said under that theory, anything the crooks didn't get, the cops could take. And either event, you'd be wiped out. So I sent it back to them. But in the process, I said that although the case was not reported to the police, any place, there's record is silent on why it wasn't. It might show a distrust by the Cardinals of the police officers involved, and that origin of that is also not in the record. So it was. I had fun with tweaking that one.
As chief judge,
Yes.
how does one try to cultivate, if you will, an environment or a sense of collegiality among so many different kinds of personalities on the bench?
It's not as difficult as you think. You have to be a schmoozer. I mean, if you try to impose your will on people, as one of my other members of the court, one who was chief judge, said, you don't have much control over them. And the answer is their certificate is the same size as yours. Every judge on the district court and in this court were appointed by the president, confirmed by the Senate for life. And they have an enormous amount of independence. To get them to work together is the problem first of a chief. And that you do by suggesting what he used to say, if you want to get somebody to do something, you make them think it's his idea or her idea. And that's the joy of schmoozing. And either from my salesman father or my Irish mother, I'm a good schmoozer. And I could ask people. But the chief of this court has got an easier job than the chief of a district court. Chief of a district court has got several personalities and trial work and so on, and they're constantly moving. Here you've got the Court of Appeals, but you have what you get from the district courts, the bankruptcy courts, and so on for the 3 states is complaints that have already gone through some filtering through the district chiefs downstairs. So complaints against judges, which are from all of these, they're the ones that come up here. You can work with the chiefs who are working against judges, which are from all of these, they're the ones that come up here. You can work with the chiefs who are working with them and the other judges, and you get to know them very well over a period of years. Remember, I've been in this court over 35 and a half years, and I've been a judge for 40 and some odd years, so I know the problems of being a judge.
One of the things I've read is that you feel a direct connection to the people who drafted the Constitution and the Bill of Rights, the Emancipation Proclamation, the great documents ensuring that America is a country where equal justice is there's equal justice under the law.
Right.
You've got a direct connection to it here.
Well, I hope I do.
Could you speak to that?
Well, you mean I carry one with me all the time, since you never brought it up. I do carry the Constitution with me all the time. I remember at a board meeting some time ago, somebody said they were trying to sneak over to see what I was reading. What I was doing was rereading the Constitution. Somebody had mentioned that some act was treasonable, and the only crime defined in the Constitution is treason. So I went to read it to him. No, I think I'm not involved in the battle of is it an absolute reading, or because I don't think it's necessary. I think the Constitution is a living document that can be applied to situations appropriately. And it's small enough so you could read it and remember it. I remember not too many years ago I was in Russia and I was working with and talking to the committee that was drafting their new constitution. They had one in 1973 Constitution that covered freedom of speech, freedom of religion, freedom of travel. So of course nobody paid any attention to it. So in '92 when they were working on a new one, they had that as a role model. And I showed them the size of ours. Theirs was, the old one looked like a Illinois telephone book. Well, it's not Illinois, let's say a small town telephone book, medium size. The new one was about the same size. And of course, it doesn't make any difference how big it is. If nobody pays you attention to it, it's not going to work. What makes ours work is that the lawyers insist it work, the lawyers and the judges insist it work. So that you can go to a judge and say, this is what's happening and is a violation of my constitutional rights, and get relief. But if nobody pays any attention to it, what difference does it make what constitution you've got? And so I think to be constantly reminded of what it says, that it means, and I do not think you can study the Constitution intelligently without reading the Declaration of Independence, because that sets out what they were complaining about. And one of the things they were complaining about is the lack of independence in the court, that they could be arbitrarily have things taken away from them. But the Constitutional Bill of Rights says what they can't do. The Constitution up till then pretty much says what they can do. It says it establishes Congress and the executive branch, president, vice president, and the courts. Then the the Bill of Rights says what the government can't do. They can take away your life, they can take away your property, but they have to do it, first of all, in criminal cases, beyond a reasonable doubt to a jury of your peers. And they can't take any property away from you without giving you just compensation determined by a jury of your peers. See, those things are the essential things, and they have to be followed. If they aren't followed, we're in trouble.
There's an elegance and a simplicity to the whole thing at the same time.
Amen.
Yeah.
Amen.
You've said that oftentimes that you just feel extraordinarily lucky to work in a profession you love.
Amen. I go to work every day giggling. I get up in the morning glad that I'm still where I was before. I like this job well enough, so I'd pay for it if I had to. No, I'll tell you, just to give you proof of that, for the last 19 years I've worked for free. Because under the Constitution I could stay home and they have to send me the money anyway.
You've also spent a good deal of time giving of your expertise. You've taught in a number of law schools. I think, what, 6 different law schools?
Yeah, I think that's right.
Yeah. Let's
Still am.
talk about mentoring young people, the importance of your role in legal education.
Well, if you think about it, I was in the state attorney's office hiring assistants, and I was U.S. attorney hiring assistants. I hired clerks. I've hired close to 90 clerks at this stage of the game or more. They're very great assistants, but what I think this is a learning experience. Almost everything you do in this business is a learning experience. Teaching law is interesting because you're telling them not just what the law is, but letting them think where it ought to be and why it's necessary we do the things we do, why you can't take shortcuts, why you have to follow the rules. You represent your client diligently, but within the framework of the rules. And the defense attorneys have to learn, if they're going to be defensive, have to learn how they answer when somebody says, how can you represent somebody that's guilty? And the answer is fairly simple. I'm just making sure the government does what it's constitutionally required to do. And if I work for people like me, the government could take away all your rights, even though you are a self-righteous twit.
That's one of the best answers I've heard of that. You've also served on a number of other boards, like hospitals, college, university
Still do.
boards. Yeah. Service is the rent you pay in life.
Yeah, service is the rent you pay in life. I don't have money. I can give them of my time and my whatever talents I have. And I give them this, but I'm not complaining. I'm just saying that those are the limitations, but the boards accept me under those conditions.
What are the I won't say causes? What are the causes that you're most passionate about in your public service?
I don't think I'm passionate about any cause except justice. I think passion is a very dangerous thing. My passion is based on the fact that you're absolutely sure you're right, and that therefore anybody who opposes you is absolutely wrong. So kind of a quiet down on passion is a good idea, especially if you're a judge. But anybody should pause and listen. Once you're so satisfied of your own righteousness, you become very dangerous. And you see that every day. There's various comments of very learned men. Pascal says, and I see if I can give you a quick quote on this one. He said, "Men never do evil so completely and cheerfully as when they do it from religious conviction." So, of course, John Adams had a great one too when he was talking about why do people commit crimes. And he said that it is prudent not to put virtue to too serious a test.
Very well put.
Yeah.
Very well put.
We don't know what we'll do when the face of temptation.
Yeah. As you look back, what's given you the most satisfaction in your career?
Almost every job I've held has given me an enormous amount of satisfaction. I suppose in working with new lawyers gives me an enormous amount of satisfaction. Watching them get better and better, and listening to great oral arguments downstairs or upstairs. Great sense of satisfaction. And there are some really great lawyers who are doing marvelous things to make sure we're free. In both a civil, criminal sense, so free to do business, free to make this a real wealthy country as well as a country of independence. You know, we've got the best legal system in the world, but you have to have access to it. Otherwise, it's simply an abstraction. And so we've got lawyers giving them their time to do it. And that makes me satisfied, too.
How much longer do you think you're going to stay?
Well, I'm above ground. No, I have no intention of retiring. As long as I think I've got my wits about me. If I start to slip. We had a judge in DuPage County. His name was Bert Rathsey. He was a role model for me. He was really a great judge. And he understood people completely. But he said one time, if I start to slip, Billy, tell me and I'll quit. And it's okay, I won't. And he did it repeatedly, he didn't do it daily, but every now and then what had happened is some other judge would come to our attention who was not in the county, but someplace else. Finally, the third judge used to have lunch with us, said to me afterwards, "Would you tell him?" I said, "Probably not. I'd probably stand behind him and try to help him." But I think he would have quit anyway if he did. He didn't. He died before his time.
I remember reading a similar story about a Air Force pilot who was getting into a jet to fly with a general, and the general turned to him before they took off. He said, "Just remember, these stars can't fly anything. If you see something you don't like, let me know."
Amen.
Yeah.
Amen.
But This has been a wonderful time sitting to talk with you. I
Oh.
really appreciate it.
Not at all. I appreciate it too. It's,
How did you feel upon learning that you were winning the Lincoln Award?
becoming a laureate,
Yeah.
I was absolutely gratified by the people that went before me. I mean, the fact that anybody thought enough of me to do that was gratifying and touching. I wouldn't say it made me humble. I do not consider myself a humble man, but I was grateful for recognition. Being judged by people you respect is very important. And almost all the awards that I've had bestowed upon me have come from peer groups or people that worked with me on hospital groups, law groups, teaching groups, and I'm gratified. Sometimes I think they're overindulging me, but I'll accept their point of view. I respect them as smart people.
Given your background and in your career, to receive the Order of Lincoln from an extraordinary lawyer, named after an extraordinary lawyer. So.
That's it. The Illinois lawyer who drafted the Emancipation Proclamation and saved the country. There would not be a United States as we know it if there hadn't been an Abraham Lincoln. It would have been fragmented. And the Constitution would not be what it is, nor would be as respected as it is.
I was interviewing someone not too long ago about Lincoln's role, and he said that Lincoln wrote every opinion as president, wrote everything while he was president, every document as president, because he knew that it was going to be analyzed by the appellate courts, the Supreme Court. He knew it would have to stand up to the test of judicial inquiry and analysis.
The last statistic I remember that Dan Ward, who was on the Supreme Court, gave me was he checked, and Lincoln argued more cases before the Illinois Supreme Court than any lawyer in the history of the state.
Yeah.
Now, he tried cases all over the United States, but this one, and yes, he did. And when you're writing, you almost accidentally write as though you're writing to convince the Supreme Court or some court of your point of view, or to convince a jury of your point of view.
I know who it was who said that now. Frank Williams, who was Chief Justice of the Rhode Island Supreme Court and a Lincoln scholar. I interviewed him last year.
Did you?
And he wrote a wonderful book, I don't know if you've seen it, it's called Judging Lincoln,
No,
where he goes back and examines Lincoln's legal decisions and documents, and spends a lot of time on the Emancipation Proclamation.
Now I have to go get the book.
And if you ever meet him, he's a hell of a guy.
I may have met him.
Yeah, he's a terrific fellow. I think we're done with this part.